to David Murphy from Jackson McDonald to talk to us now about mergers and acquisitions in the charity sector. Thank you, David.
Thanks very much, Ian. Good morning or good afternoon, everyone, depending on where you are. So look, this is going to be a bit of a whirlwind tour of the legal issues that commonly arise in merger and acquisition transactions in the charity sector. I just wanted to start with, well, what are some of the reasons why M&A transactions take place, with a particular emphasis on crisis, but also I think this could apply generally in good times, so to speak. And so the first one I've got up there, which is the most common one, and that is funding and solvency issues. So what we've been seeing probably in recent times, particularly myself, is where there's a loss of a contract, so a key contract that results in the key amount of funding, and for various reasons that contract may be lost. And the other one that we've been seeing quite a bit is where charities are reliant on corporate and or public donations in order to fund their activities. And given the current economic climate, some of those corporates and some of those key public figures who may normally donate are not. So that's, I think out of all these, that's really one that's probably come to the fore during the coronavirus crisis. The next one, there are change of demand for services. I mean, obviously, these couple of examples are, particularly in Perth, the demand for emergency hospital services has, I think, during the peak of the pandemic here was, severely reduced. There were almost no one in emergency departments. Similarly with, universities where there's going to be a question of demand in light of the fact that international students can no longer travel here to take up courses. But of course, it could apply to smaller charities as well. And the next one there, competition, both increased and decreased. I think the increase, speaks for itself. But we have seen some charities taking opportunities to actually, think it's a good opportunity to go out there and sort of purchase some other charities that may have fallen on some harder times. So there are a few charities out there who consider this as quite a good time to go on the acquisition trail and perhaps by incremental means expand their purposes. The last two there, change in law or government policy, and then the change of purpose. So I think there were so many changes in law and policy that happened during COVID. It was hard to keep up with them all, to be honest, as a lawyer. But I think when JobKeeper ends, when it finally does end, we'll see what happens in the charity space and whether or not that results in some charities having to pull the pin and potentially merge. And lastly there, I think change of purpose, again, this can apply generally, but if you have fulfilled your purpose or as a result of Corona or some other crisis, you need to change that purpose, then perhaps you may be looking to merge with another charity who has that purpose you intend to carry on. We'll just go to the next slide. So I'm just going to talk generally about a general framework for mergers and acquisitions. And I've got a couple of steps here where there's sort of three steps I'll go through. This is really, it's a combination of buy side and sell side. So it's really looking at the transaction holistically. And I've got step one and step 1A here because they're very much intermingled, and step 1A will very much sometimes determine what you can do in terms of step one, because restrictions in your constitution, etc., may impact on the transaction structure that's listed there as step one. So just focusing on step one, what we're really talking about here is, well, what is the transaction? What are we going to buy? What are we going to sell? So some common transactions are transfers of assets. So charity A transfers all of its assets to charity B, or charity A and B transfer all their assets to charity C. So a new charity is created, and two existing charities transfer their assets upwards. Transfer of shares, probably less common, but some private companies are charities. And it's possible to affect a merger by a transfer of shares. The third dot point there, transfer of membership. So what I'm talking about here is where you've got a public company limited by guarantee or an incorporated association, where technically you can't actually transfer membership in those types of legal structures. It's non-transferable. But of course you can issue or appoint new members. So I have been involved in a few transactions where at settlement, a charity comes in as the sole member and the old members cease to be members, and the charity coming in purchases the charity by essentially taking the sole membership in that charity. Liquidation, what I'm referring to here is really a technical liquidation in terms of a legal winding up, so where a liquidator is appointed to determine the assets and liabilities of the entity, and the liquidator then pays all the liabilities and then does distribute the remaining assets to another charity in accordance with the terms of its constitution. And the last one there, amalgamation, which is just that I think in most states there is a process under the various Associations and Corporations Act to actually, through a process under that act, amalgamate two associations into a third, well, a standalone, separate incorporated association. So as I said, step 1A really is linked to step 1. And here we're talking about what I refer to as the internal requirements in order to effect the merger. And the two key points here are the first two dot points, and that is there a power to effect a merger, and will the merger advance the charitable objects of the particular organisation? And normally we're looking at this from the sell side. So to give an example, if a private hospital, which is a charity, is going to acquire a creative arts charity, one would have to question how that acquisition would in fact advance the objects of a hospital. So that, I think the key thing here is looking at the particular objects of the charity and then determining, well, is this transaction going to further those objects? Now, sometimes that involves having to amend the charitable objects in order to make the transaction fall within them. But then, of course, you need to think about, well, how's that going to affect any DGR status or income tax exemption status? Constitutional requirements. So look, I have seen all sorts of weird and wonderful things in constitutions in terms of restrictions. Sometimes in order to sell assets over a certain amount, you need member consent. Not always, but that's a common one that I see. Sometimes constitutions or trustees require that the consent of certain persons be obtained, key stakeholders or a certain council that's associated with the charity be obtained before a charity can affect a transaction in an M&A context. Compliance with winding up clause. So really what I've been talking about here so far is M&A in the context of using a power to transfer assets rather than going through your winding up clause. But technically, if you do have a liquidator come in and technically wind up, then you will need to comply with that clause in your constitution. And in fact, most organisations, if they're not technically winding up, tend to comply with that clause, even if they're just transferring all their assets. And commonly, these clauses will say, particularly if you're a deductible gift recipient, that you need to give your assets to another deductible gift recipient that has similar objects to your own objects. And the last point there, which we could talk about for a couple of hours, is obviously you need to consider the transfer duty, income tax and DGR considerations of a transaction and whether or not it will affect those statuses that the charity may have. So step 2, and many commercial lawyers will be familiar with this, but this is the context of taking what I call external due diligence. So this is looking at precisely what we're going to acquire. So this is identifying the assets, the contracts, the liabilities, identifying the key employees and whether or not you wish to acquire all of the employees or only some of the employees. Are there any potential liabilities on foot, litigation on foot? Has an employee made a sexual harassment claim? So it's discovering those things about the entity that you're going to buy. And it's a key risk mitigation process, due diligence for the acquiring entity. Last couple of points there, which is consents. So often if you want to transfer assets, you need the consent of the contracting party, removing encumbrances over assets, so things that are items that are on the PPSR will usually need to be removed before you can transfer assets, and then of course the financial DD as well. And look, just quickly, you know, once those initial steps are undertaken, well, then there's obviously the process of putting the deal into writing and then effecting completion or settlement of the transaction, which is very much process driven. I am running out of time, but I just wanted to quickly comment on one of the issues we discussed. Was obviously this can take a fair amount of time to actually affect a merger or acquisition. So if it is the case, sorry, Ian, next slide. What are some of the things we can do where transactions need to happen quite quickly? And I think the first point is communication, and that is communicating to your employees, clients. It is going to be a much smoother process, and you'll get a lot better buy-in if that communication piece is being taken care of. Understanding your key contracts and your clients, and what I mean by this is, you know, you do need to have a grasp of the key terms of the contract, how long the contract is going for, who your clients are. You know, if you need to get up to speed on those things, it's going to be very difficult to effect an M&A transaction quickly. Obtain advice where possible. And the last two, which is, you know, focus on the key due diligence items. And I think you need to approach this on some basis that, you know, some things will be missed. And I think it's a case of focusing on those key items and not sweating the little things. So I have gone over, apologies, and I'll pass back to Ian.
Thanks, David. That was really helpful, I think, just to go through that and give us a sense of what we might need to do. All of us might need to start thinking about quite hard given the circumstances we're in.